Bonjour and welcome back. This second video will visit the distinction between natural and juridical persons. And we will start a conversation about human embryos that will be pursued when we meet live in the Friday class. I'd like first to visit the concept of person and where that word person that is so commonly used, where is it coming from? Person comes from the Latin persona. Persona comes from a very old word, an Etruscan word that was persu, and persu described the actor's mask or the character in a play. And I like to visit that etymology of person because person is actually a legal construct in the civil law. A person is actually your character, who you are in your legal life. When I discuss mask, I mean theater mask, not these horrible masks that we have to wear, but please continue wearing them because our safety is at play in these COVID days. So the Civil Code of Louisiana tells us that there are two kinds of persons: natural persons and juridical persons. And you may wonder what that is, because probably when you think of persons, you think that people like you and me, of individuals. But a natural person, says the code, is a human being. And the law, the code, is telling you from what time and until what time you are regarded as a natural person. Your life may commence with conception, because you would never be born as a child if you have not been conceived. But natural personality commences from the moment of live birth and terminates at death. That means that you may be a human being from the time of your conception, but you are a natural person only from the time of birth till the time of death. And the concept of person is very important because as a person, you are recognized the capacity of being a subject of rights. You can have rights like the right to inherit, the right to own, the right to contract with your fellow human beings or other natural persons, or with juridical persons or legal entities, corporations that we will discuss in a moment. But you do not have this personality before you actually come in this world. However, Article 26 is telling you that an unborn child shall be considered as a natural person for whatever relates to its interest from the moment of conception. What does that mean? That means that sometimes the law allows you to have rights though you are not yet born. If the child is born dead, it shall be considered never to have existed as a person, except for purpose of action resulting from its wrongful death. A contrario, you can say that if the child is born alive, the child may have rights that have been acquired during the time between conception and live birth. Look, here I am showing you are regarded to be a person, which is between live birth and death. But imagine a child who is not yet born, but the father happens to die while the mother is pregnant. child going to be fatherless? Are you going? It's an unhappy event inheritance before your birth. So you are fatherless and you don't inherit from the child. The law, thank goodness, allows you, if uh, you had been conceived before the death of the father, which means if you were born less than 300 days after the death of your father, which is the legal longest period for conception, you may actually inherit from the father. And that rule existed already at Roman law. It was there already in the law of the 12 tables. So as a rule, your legal personality starts at birth, but at times your personality is sort of retroactive. And if you were already conceived at a moment when a parent died or someone from whom you could inherit died, you will be allowed to inherit. Let us look now at juridical persons. A juridical person, says the Louisiana Civil Code, is an entity to which the law attributes personality, such as a corporation or a partnership. The personality of a juridical person is distinct from that of its members out of convenience, and this is a sort of fiction. We give the attributes of natural person to legal entities. A legal entity can have rights and can make contracts in its own names. Of course, a legal entity cannot sign legal document. It has to act through representatives. And we are using the legal technique of mandate, as we call it in the civil law, or agency. You have agents or mandatories who are going to contract or represent the juridical persons. But remember this, two types of persons, natural persons like you and me, and juridical persons who may be profit or non-profit legal entities. I come back to legal embryos, and you will discover, and that's the work that you'll have to do for Friday's class, that the revised statutes are making provisions regarding human embryos. Till a recent period in our history, we only knew of embryos who were in the womb of the mother. But nowadays, with technologies, we can have test tube babies or frozen embryos. And we will discover what the legal status of frozen embryo is in Louisiana law. I won't say more at that point. What I want now to indicate that any person, natural, be it natural or juridical person, has a patrimony. Patrimony is a very abstract concept. What does it mean to have a patrimony? Some dictionaries are going to translate by estate. You understand that it has to do with what you own, but also sometimes with what you owe. Actually, your patrimony is the balance sheet that any natural person or juridical person has at any moment of its life. At any moment of our life, we have assets, anything we own, money that is owed to us. All these are the assets, but we also sadly have liabilities, like a loan that you have to repay for the purchase of your car or your home, or student debt, or any money that you owe to someone else. So everyone, be it a natural person or a juridical person, has assets and liabilities. And this is what we mean by patrimony. Uh, Aubry and Rowe, French scholars, have developed a rigorous theory of patrimony. And there are three principles that are clearly articulated in Aubry and Rowe's writing, and many civilian legal systems follow this doctrine, saying that only natural and juridical persons have a patrimony. Your pets, your dogs and cats or rabbit or whatever you have do not have a patrimony. Actually, they are an asset in your patrimony because the law looks these dear things as things we own, and they may have a value. Some of you have paid for their pet. It's only natural and juridical persons that may have assets and liabilities. That's principle number one. Principle number two is that every person, natural or juridical, has one and only one patrimony. You cannot say that, oh, I have several patrimonies. I have my personal patrimony. I have my family patrimony, where I may share assets with members of my family, and I have my business patrimony. It doesn't work like this in the civil law. You may have several accounts, but if you are listed, as a holder of the account, all these accounts are entries in your one patrimony. You may, however, decide to allocate part of your resources for your business. But typically, what you do when you want to do this, you create a partnership or a corporation for that patrimony to be separated and to limit your liability and to avoid things that you own for the use of your family to serve to pay debts that are your business debts. That's the reason why we are using juridical entity to operate our business, because at least according to the civil law, because the common law doesn't have this doctrine of patrimony, in a civil law, we have just one patrimony. That's the rule. As every rule, there may be exception, but you have time to discover those very few exceptions. And the third principle, which derives from the two others, is that the patrimony is inseparable from the person. So from the time of your birth to the time of your death, you have a patrimony. Things are going to change. Your assets fluctuate all the time. Your liabilities also fluctuate. And I wish you all the best, that at all time in your life, your assets exceed your liabilities, because if liability exceed the assets, you may be bankrupt, and this is very bad news. And this patrimony, as a rule, is indivisible. That means that if you have liabilities, the creditors will be able to collect any of the assets that you have, and none of them is going to be protected. However, some debtors may have preferential rights on some element of your assets, but that does not change the rule of the indivisibility of the patrimony. So the patrimony is a sort of envelope, is a sort of balance sheet that is fluctuating at all time. But remember that whenever you are discussing a person, natural or juridical, there is a patrimony out there with assets and a liability. Since this is Halloween season, I have this funky picture rather than a human face. We will continue this presentation to understand other categories, at least to discuss the rights that natural and juridical persons may have. and discuss more in detail the entries that you may find in a patrimony. Thank you for your attention and see you next time.